Hello and welcome section members. My name is Mike Hargett and I'm the Real Property Probate and Trust Law section of the Florida Bar CLE co-chair for Real Property. This is a complimentary CLE on behalf of the section. This presentation is applicable not only to real property and probate and trust practitioners, but likely our partners, whether they're in the corporate department, general litigation, or in family law. Feel free to send a link to this presentation to your partners and friends. My goal today is to ensure that you do not find yourself facing federal criminal prosecution for money laundering, for doing exactly what you've always done. That's why there's no charge for today's presentation. I mean that. When I first read the new rule, I was certain that unless I changed, I would break the law before Christmas. As we know now, the implementation was delayed by 3 months, so it would be sometime in April. Under the new FinCEN residential real property rule, merely having your name in a quitclaim deed legend and having that deed recorded is a crime in many circumstances if you do not report the transaction to FinCEN. Now let's talk about what the rule is not. Remember the Corporate Transparency Act? The federal law passed by Congress in 2021 that took until 2024 to enact. It was enacted by Congress with the goal, quote, to make it more difficult to use shell companies or other ownership structures to launder money, finance terrorism, and other activities that harm U.S. national security and economic interests. As most of you know, that act was initially enjoined, then stayed, and finally suspended last year. There's a great article on the CTA in the August-July 2025 Florida Bar Journal if you want to read up on and learn more. However, the new rule is not a reboot of the Corporate Transparency Act. Secondly, the new rule is not a geographic targeting order, which places a duty on title companies to report certain residential transactions in specific counties around the country, including several places in South Florida, Las Vegas, San Francisco, and others. I mentioned GTOs because the new rule will feel fairly similar, but is much broader. The reporting requirements are more detailed, and the legal duty and criminal liability is placed on you, the practitioner, in several circumstances. Now, remember the CTA because there are beneficial ownership concepts and control concepts in the CTA that carry forward into the new rule. Today, we're talking about the FinCEN residential real property rule. I'm going to refer to it as the new rule throughout today's presentation. It was enacted by the Department of the Treasury under the Patriot Act and is a companion to the Banking Secrecy Act. FinCEN is an acronym for Financial Crimes Enforcement Network. It's designed to reduce money laundering activities involving residential real property. Now, I was fortunate to speak with several section members that represent many of our title companies at the national level. Therefore, what you're going to hear today is not my personal view, but it's the opinions of several key leaders in the title industry, and they have thankfully answered all of my questions and helped me. Now, one thing to remember, the feds love the database that the GTOs were creating, and certainly they're looking forward to the database that's going to be created by the new rule. Now, don't write anything down yet. This is the basis for where this rule comes from. You have the Federal Register Volume 89, number 168 in your materials. I would jot down the 2-page numbers that are highlighted in yellow on this slide. 70258, that's where you'll find the summary and background, and 70290, that's where the rule, section 1031.320 appears. I found it difficult when I had the Federal Register in my hand to flip back and forth and find the start of the rule because it's written in that wonderful presentation. It makes it a little hard to find where you're at from time to time. So do write those 2 page numbers down. Let's talk a little bit about the roadmap today, what we're going to be doing. We're going to talk about what transactions are covered. I've got at least 4 key practice points and required expertise we're going to focus on. 3, we'll hit on the legal duty to report and the criminal liability associated thereto. We're going to talk for a little bit about the status of the injunctive litigation. And then we've got specific scenarios applicable to real property, probate and trust, and corporate and beyond. Finally, we've got some additional education. One thing that I'm doing today is I'm focused on not on exactly how you report and how a transaction operates, because our title company representatives and partners have got great CLE on that. And I'm not going to spend a lot of time on the estate and trust exceptions, which the section worked on for more than a year and has put in place because we've got specific CLEs that cover that. Instead, I'm looking at this from a risk, from a personal risk, and from your law firm risk analysis, and trying to point out areas that you should be concerned. Now, we're at practice point number 1. The new rule is a companion to the Banking Secrecy Act. Because of that, you're not required to report when banks have to report. All our market center banks, Truist, Wells Fargo, etc., they have a duty to report suspicious transactions under the Banking Secrecy Act, and the feds don't want to hear twice about the same transaction. So this is important. This is an important point. If you have a real estate closing where a market center bank is providing financing that's secured by a mortgage, then you do not have to report because the bank will do that reporting to you. Now, how do you know what a market center bank is? How do you know that they are subject to the Banking Secrecy Act rules? I'm going to tell you, first off, the Bank of Dad is not a market center bank, and Wells Fargo is. Beyond that, you need to know that yourself for 2 reasons. First reason is you may be liable if you get it wrong, and I don't think I'd trust that with anybody but me. Secondly, based on my experience, your toughest sell is your client. Your client is the one that is not going to want things reported, and they're going to be pretty reasonable in that, because who wants to have the birthday, Social Security number, and ownership interests of my granddaughter put in a federal database? So you need to be an expert here. You being conservative and over-reporting, like the title companies certainly will not endear you with your clients. Now let's talk a little bit about applications. As I've mentioned, we're not talking about when you have secured lending from a market center. That's a general overall exception. The second piece, we're talking about residential real property located anywhere in the United States. And now when I say that, the GTOs were very specific as to counties, and they were very limited in duration. This is a forever rule, and it covers all real property that is residential located anywhere in the United States, transferred for any or no value, where the transferee is an entity or a trust. Now, there are some limited exceptions. So what is residential real property? That's practice point number 2 for today. The definition of real property is very broadly defined, and you or your firm needs one person to go to say you're inside the reporting rule or you're outside, and I don't think that person needs to be a first-year associate. You need someone that's going to establish this liability for the firm. So we're We're talking single-family homes, duplexes, triplexes, quadplexes. We're talking vacant land intended for residential use and co-ops. But the big question, is it broader? So the definition, one of the language used in the rule is real property located in the United States containing a structure designed principally for occupancy by 1 to 4 families. So an apartment complex above a bakery, that counts. Secondly, the definition includes land located in the United States on which the transferee intends to build a structure designed principally for occupancy by 1 to 4 families. Okay, it's intent. It's intent of the buyer at the time of closing. One issue I've heard discussed, and it makes reasonable sense, why would you not want to have an affidavit for your buyer to sign at closing that declares his intent? I'd hate to be on the wrong end of an investigation when your buyer intended to purchase this residential lot for investment purposes. I wanted to resell it and make some profit on it. I thought it was a good deal. I wanted to flip it and later instead builds. So I think it would be beneficial for both the firm and the client to have the intent documented at the time of closing. Now, second, it's a unit designed principally for occupancy by 1 to 4 families within a structure on land located in the United States. Clearly here we're talking about condominiums. So a unit designed for occupancy within a structure, but would it expand to an apartment complex? Finally, shares in a cooperative housing corporation for which the underlying property is located in the United States. What about an LLC that owns the residential real property and you're simply transferring the membership interests? So we're going to go to the waterfall, which defines the legal duty, and with the legal duty, the criminal liability. There are 7 categories in this waterfall. You start with the person listed as the closing agent. Usually that'll be identified on your settlement statement. If there is no one identified as the closing agent, it would be the person who prepares the closing statement. If there's no one designated as preparing the closing statement, go to the person who files the deed with the recording office. Following that, we have the title insurance underwriter. And importantly, remember with the geographic targeting orders, that was number 1, and the only legal duty was with our title underwriters. Now they are number 4 on the priority list. If you can't determine that, the person who disperses the greatest amount of funds, followed by the person who provides the title evaluation, and finally the person who prepares the deed or other legal instrument. Now let's discuss accommodation deeds for just a minute before we go to the next slide. An accommodation deed for purposes of today is a deed that generally falls outside of title insurance. It's a quit claim deed. I want to transfer property from me personally to my LLC. I want to transfer property from me to my trust. And title companies used to record these deeds for us until the liability became too high. So for today's purposes, it's a deed where you're not using a title company. And if you have an accommodation deed, you can strike number 1, 2, 4, 5, and 6, and you're looking at the person who files the deed with the recording office or the person who prepares the deed or other legal instrument. So think about this carefully. Trouble abounds here, and there's high risk. So let's take a couple of examples here. I've drafted lots of deeds to LLCs over the years, and so have my partners, whether they're estate and trust attorneys or corporate counsel. So I have a client that comes into my office with his wife, and the two of them are financially astute, and they never sold their first home. Instead, they turned it into a rental property. Smart investment for this couple. I realized that the property is still held husband and wife, TBE, and the instant thought that comes to mind is, well, they should hold that property in an LLC to get the corporate liability shield against a slip and fall or some other accident on the property, and the judgment from that exceeds the value of their property insurance. Fairly common. I've done it countless times throughout my career. But guess what? That deed from a couple to their LLC is a reportable transaction, and if you don't report that transaction, you've committed a federal crime. Second area that I would be worried about, because in a lot of our offices, we have administrative assistants or we have paralegals that record deeds on Simplifile. Now, a lot of people help their friends out, they help their family out. Doing that can easily create a reportable transaction simply because you reported and recorded that deed. Now at the bottom it mentions other legal instrument. And we'll get to that in just a moment. But think about this: if FinCEN is doing an investigation, they're going to go to the real property records. The first thing they're going to see on that deed is the top left-hand corner where the legend is that says, prepared by and returned to Michael Hargett. I think that means at a bare minimum, they're going to give me a call and ask about the transaction, which raises the question of what records did I keep that helps me understand and prove that I'm not the person with the legal duty. So that other legal instrument language, and for a lot of you that are real property practitioners, you'll recognize the term conduit entity, and that's from the Florida Administrative Code, where we're dealing with documentary stamp tax. And it was a plan used by a lot of people to put a property into an LLC and then transfer the deed to avoid Florida documentary stamp tax. So think about a valuable piece of residential real property. It's waterfront. It might be worth $5 or $10 million, and it's held in an LLC. And to avoid reporting, I could transfer it from one LLC to another, transferring the ownership of the real property. But if no deed is involved, the definition is then the person that prepares any other legal instrument that transfers ownership of residential real property, including with respect to shares in a cooperative housing corporation, the person who prepares the stock certificate. It raises an open question, which is not answered today, on whether or not a membership interest transfer agreement drafted by your corporate partner, transferring a special purpose entity that only holds residential real estate, would be deemed reportable. That's a decision that you and your law firm are going to have to make on your own. Now, a lot of people were hoping this rule would not go into effect, and were encouraged by the prior delay in implementation, and that was in the case brought by our title company and section sponsor, Fidelity National. We certainly thank them for their efforts. They filed a wonderful case for injunctive relief. The citation for the case is on the screen. Don't bother to write it down. A copy of that case is in your materials, so you've got it. I will tell you that on December 9th, the federal magistrate judge recommended finding in favor of the new rule in favor of the government. As expected, Fidelity filed an objection this month, and the government filed its response about 2 weeks ago. So stay tuned. No one knows, but all the title companies are preparing to fully comply with the rule on March 1st, and you should too. Will it last? Will it end up being something like the Corporate Transparency Act? Who knows? The people that I've spoken to say no. You know, there's no consensus there, and nobody knows the president's position. Certainly, the Justice Department is using the Banking Secrecy Act to investigate officials in Minnesota right now. President Trump has displayed a disdain for the drug trafficking and money laundering as evidenced by his actions in Venezuela. At the same time, he's probably going to hear from wealthy donors who are unhappy about the detailed disclosures required under the new act. Those include identity, address, date of birth, and social security numbers of beneficial and controlling interests in these entities and trusts. Remember, the National Defense Authorization Act contained the Corporate Transparency Act. President Trump vetoed that, but the bipartisan support was so strong it was the first veto that was overturned in President Trump's first election. Bottom line is, be prepared for this new rule at the end of the month, but stay tuned and keep paying attention. Now, I will tell you that my thoughts about the act have changed to some degree. 3 months ago, I thought that people that were traditional real estate practitioners who use title companies as closing and disbursement agents really had nothing to worry about. I'm going to talk about the contract gap a little bit. On March 1st, you're going to have contracts in place for the transfer of real property, and those contracts did not contemplate this act going into effect. So you could end up with a situation where neither the buyer nor the seller are contractually obligated to comply with the new rule. The concept of disclosing information to the federal government by the seller is a new concept. And remember, the title company is not going to close the transaction without compliance. They'll simply not take the risk. The fees they earn are not that high on a per transaction basis, and they certainly don't justify criminal liability. So whether or not you have an issue will depend on the specific language in each contract. So the bottom line is, you need to review these contracts on or before February 28th to address any issue as soon as possible. And frankly, I would be looking at closing schedule for the last week of this month to make sure they close. It's better to head off a problem now, whether there's nothing you can do about it and you just need to, let's get an amendment in place so everybody knows what's going to happen and what to expect, and flesh that issue in now. Now, early, sooner rather than later. Don't write this down. This is too small to read. But this is the proposed language to go into the FAR bar to make it clear that everybody's obligated to comply with the new rule. You've got a copy of this language in your materials. I think it's the very last page. All right. Now, reporting under the new act is not free. As I mentioned, it's more onerous than the GTOs. There are 111 required data fields. It contains information on both the buyer and the seller. The buyer is more detailed. The estimates I've seen range from 2 to 5 hours of input time. And that excludes the time required to get the information from your client, who's not going to be thrilled about giving it. So this is not free. There are services out there that will do it for you. Those services also charge a fee. Now, we're going to talk about 5 different scenarios here. And so you can find the right product to support you. Remember, your title company is going to support you if they are at the top of the waterfall because they have the legal duty to do so. But if it's an accommodation deed, you're unlikely to find a title company that will support you. There are third-party companies out there offering products that will. Now, additionally, just so you know, these title companies may or may not have cut a deal with some of these third-party reporting companies to where you can get a discount. So reach out to your title company that does your work for your firm. Ask them who they would recommend. You might pick up a discount. So let's look at these examples. So the first one is traditional real estate closings, where there's an independent title company or title insurer as the dispersing agent. Remember, so that for you will likely be business as usual, other than the contract gap we just talked about. The reporting duty is going to fall on the title company. which should be included in your closing instructions, and you should confirm that the companies have this responsibility and have accepted it. Now, you're relying on the waterfall here, and you want to stay off the waterfall in this situation. You should avoid drafting deeds or putting your name on a deed where possible. Further, you should never be identified on the settlement statement as the closing agent or settlement agent or handle the disbursement of any funds in this scenario. The simple identification of the firm's legal expenses as a line item on the settlement statement should not create a concern. That's your first scenario, traditional real estate closing, independent title company or title insurer as the dispersing agent, should be business as usual. Second is the traditional real estate closing, but you act as the title agent and disperse funds. Whether it's you or your paralegal, the legal reporting falls on you and your firm. Many of you will engage a third party to provide those reporting services, as we spoke about a moment ago. The legal duty won't change because no third party is going to accept that much liability for a service that costs, $100 or $200. So remember, attorneys must become experts in determining whether or not each closing requires a report, that 100% of the required information is obtained before closing, because if you don't have it all, it doesn't count as reporting. One blank field. And you've got to make sure that the reporting responsibility is timely completed for each and every reporting transfer. Note there are multiple CLEs available from the title industry on this specific topic. Missing one of the 111 data points is certainly a problem. Finally, we get to accommodation deeds. Examples: deeds to LLCs for the liability shield, deeds to revocable trusts, deeds to family limited partnership, and deeds to revocable trusts. The legal duty follows the waterfall, which means you, as the recorder or drafter, have the legal duty to report. Now let's talk a little bit about exceptions, because there are exceptions to those examples. Those exceptions are for transfers resulting from death, transfers incident to divorce, transfers supervised by a court, and transfers to certain trusts. Now, most of these exceptions are outside the scope of today's discussions, and we've got a recommendation for a CLE that we'll get to a little bit later. But I do want to spend a little bit of time talking about a transfer supervised by a court. What does supervised by a court mean? Not sure that it means that we have a settlement agreement that the court approved, that as part of that settlement agreement, real property is transferred. I don't think you get it. And in fact, I think you should think a little bit about, what does a judgment on a quiet title action look like? Judgment in a quiet title action usually has language transferring the ownership of the property by that court order. I think I'd much rather have an order like that than having a deed with my name as prepared by and returned to. So an important practice point, and our fourth practice point of today: who is your exception expert? Who's the person at your firm that's going to say, this particular trust is exempt and this particular trust is not, and why? The strong practice point here is you or your firm should become an expert in these exceptions and be the person ready to call the balls and strikes when these issues arise. Now, from an educational standpoint, we've got two outstanding speakers. This is Marvianne Alamo and Andrew Thompson. They've got a CLE on what every estate planner needs to know about FinCEN's residential real estate reporting rule. That CLE will record on Friday, a week from this Friday as I'm sitting here speaking. That will be February 13th and should be available shortly thereafter. We're going to try to give you a link to that course when we get to it. and hopefully there'll be a link that'll appear at the end of this presentation. Finally, for your real property closings and for questions about exactly how do you report, what do you report, reach out to your title company. They've all got great educational programs that are available for you to watch right now. I've watched several of them myself. They do a wonderful job talking you through one of the traditional real estate closings and the rule. And it'll make a great complement to what you're learning through today. Those, to my knowledge, are all free, particularly if your title company, if you do have a relationship with your title company. So first off, we can't thank our title industry sponsors enough. Our title industry sponsors are fundamental to Reptile. Not only do they support us financially, the number of presentations they give and have made in our committee meetings, the expertise they bring to the table each and every week, and those CLE programs are invaluable to us, so thank you. I will say that said, I got to give special thanks to 3 individuals, Alan Fields, Lynn Prescott, and Jim Russick, who put up with me over the past several months. They've answered all my questions, no matter how ridiculous and unthought out they were. They were there day or night, weekend or holiday. I can't thank them enough. Now, as a bit of a summary, these are your key points. First, market center banks. Someone in your firm needs to be the go-to guy or gal for that bank is covered, you don't need to report or not. Maybe a different person answering the question of what is residential real property, and does the property I'm transferring fall within that definition? Third key point, the open contract issue, the issue of contracts that don't require the buyer and seller to comply. Look at that this month before we get to the end of the month. Fourth, establish your exceptions expert for transfers incident to death, transfers supervised by a court, and transfers incidental to divorce. And finally, watch out for those last-minute rush changes that happen so frequently in real estate transactions, and everybody's pushing you to close, especially the realtors. Think of the classic case of my loan didn't go through, but I went to my dad or other hard money lender and I have my loan replaced, or I will close with cash. You've got a transaction that has been deemed I don't need to report until the last minute when the financing falls through, and all of a sudden you've got a reportable duty and a lot of data to start collecting at the very, very last minute. So I appreciate you being here with me today. Again, Marvianne and Andrew's CLE, hopefully that's what every estate planner needs to know about FinCEN's residential real estate reporting rule. Hopefully we'll get a QR code for you so you can link to registration right now